Okay, so now we're going to ask Barb to do some education for us.
Okay. Good afternoon. Thank you for the invitation to come and speak to the board about compliance with Ohio Public Records. As already been stated at the meeting, the city of Dayton has an interest, as does the board, in being transparent and complying with the law. I will note just at the outset that Mr. Kidwell is your attorney, so if there are questions, I would definitely encourage those. But if they would amount to a legal question, it would be most appropriate for Mr. Kidwell to answer that. Mr. Kidwell and I have had numerous conversations in gearing up for this in regards to the approach. So the four topics specifically that I'm going to address are public meetings, public comments, executive session, and public records requests. Public meetings, what does that mean? It has to be open. It has to be in a geographical location of the jurisdiction, which in this case would be the county, because the city and the county, from a legal sense, own Preschool Promise. So the location that we're at, it has to be accessible. And what is a meeting? What is a public meeting? It's a prearranged discussion amongst the majority. So for this board, that would be 3 or more members. And again, you have to be talking about Preschool Promise business. Having a conversation not about business would not fall within purview of the law. And again, also one thing I would note to kind of think about is we dig a little further into the weeds. When subcommittees are created, think about what a majority for a subcommittee would be as well, because that number is always going to be less. So just something to keep in mind. One-on-one discussions, even about business, would not be a violation. What are work sessions? Work sessions are just a more in-depth conversation. Usually involve staff or a consultant. It's open. The requirements of an open meeting still would apply to a work session. I could not think of a good example that would apply directly to Preschool Promise, but as time progresses, there may be opportunities when you want to have a work session. You would treat it just as you would a regular meeting. Again, we talked about the location. One thing that I would note, if you're ever in a situation, and we face this sometimes at the city, where your space could limit attendance, you closed circuit, courts have said very clear closed circuit, TV showing what the meeting is going on in a separate room so that there's more room. And we do that at the city sometimes when we have very large attendance at meetings. Again, this will kind of be a time will tell in regards to this board and attendance if that's an issue. Meetings must be open the entire time. The only exception to that would be if you go into an executive session. Mr. Kidwell and I have had conversations about that. You can only go into executive session for the law mandates, I believe, 9 or 10 different topics that would permit you to go into an executive session. In regards to public comment, the way that things work at the city, we have a form, which I provided to Mr. Kidwell, that we use at the city, where you can sign up before commission meetings, letting us know what you want to comment on. Permitted to come up and engage, obviously, and we have time constraints of 3 minutes so that everyone has the opportunity to engage and be active. There is no mandate from the law that comments be permitted, and if commenting is going to be permitted, and we again have talked about this, there would be the discussion about setting the limits on time, place, and manner, and that would be something that the board would need to discuss. In the city's instance, non-registered speakers and who don't comply with what we have in place would not be in a position to comment. We also ask that you only comment once during the meeting. That's just, again, the restrictions that the city has put in place considering the topics and the attendance and those types of things that we deal with. Thinking about disturbance of meetings, I'll have off-record conversations with Mr. Kidwell about that, but just that's something that I would, the board would need and be in a position to understand if that would happen, how to handle it in a situation. There are situations where criminal charges can result from activity by the public at a meeting. So and again, these are extremes, and as an attorney, sometimes that's the world that we live in. So, but just knowing and being aware of that. When you have an open meeting, of course, the public is permitted to record. The law doesn't permit for you to put prohibitions on that. You can, however, put some restrictions in regard to it has to be unobtrusive or silent if you're going to be making a recording. So those are things to kind of be thinking about as well. And I'll use this opportunity to say in no way, shape, or form is the information that I'm providing you today a good, fair, 100% substitute for the training that's available. In regards to the sunshine laws here in Ohio, I know that there's an in-person one coming up from the Ohio Attorney General in March. You can do this training online through their website before then, and I would encourage all of you to engage in that. The sooner the better, just to get a really good foundation as you lead the board in Preschool Promise. So we talked a little bit previously about executive session. These sessions, again, are the exception to the rule that meetings must be open. You can invite anyone that you choose to attend an executive session. And I know, again, Mr. Kidwell can go in more to the logistics of this, but one thing that I would note that is important is that you are having a regular meeting or a special meeting and you adjourn into the executive session. You're not going to be permitted to vote in the executive session. You come out of the executive session, and if you're going to vote at that point in time, you would do it at that. It's a roll call vote as well. The law is very clear about that in regards to the executive session. Some of the topic matter that permits you to go into executive session, again, this would be a closed meeting, would be personnel matters, purchase or sale of real property, pending court action, collective bargaining. If there's a federal statute that mandates that this is something that can be kept confidential, that's an example of permissible. Oh, wonderful. Security matters, hospital trade secrets, and confidential business information. Again, some of these are not going to be applicable to preschool promise, but I'm just kind of giving you a broad overview. In regards to public records, I think this is going to warrant more of a conversation, and I don't know if you kind of wanted to pick up, talk about what you handed out, or...
Well, that was just a form for executive session. We took the ones that, if they could ever come into play possibly, and left them on the sheet, but this is a template that you would be able to follow in going into executive session by declaring a motion. Time you go in, take the roll call vote. The matter you go into must specifically be noted. There's an Ohio case that came out not too long ago that was general in terms of the nature of going in for a employment matter, but it was actually much more in-depth, if I remember right, in terms of a termination, disciplinary situation. So the court said you have to be very specific, which is why kind of giving the boxes here that the statute follows. And then at the end, you come out of executive session typically with a recommendation to the board of what the action item is, or you can come out of executive session and recommend no action on an item. So that way you have something that's in the writing that's part of that process.
In talking, talking a little bit about public records and public records requests, any documents that are generated by preschool promise are going to be public documents, which means that someone makes a request, they have the ability to have access to it. And again, the law just defines it as any document that's kept by the public body. And it goes further than that in regards to document, device, or item, which includes electronic records. So if there are documents that have been created for preschool promise and or received by preschool promise, which serves to document the organization, the functions, the policies, the decisions, procedures, operations, or any other activities, it's going to qualify as a public record under the law. Easy examples would be meeting minutes, emails about preschool promise business, but it also includes text messages. In the last couple of years, we've seen some shifts in case law in regards to text messages qualifying as public records. If you are doing preschool promise business via a text message, it's going to qualify as a public record. An exception that is held steadfast through the law are personal notes. If you're taking personal notes for your own convenience or to be able to recall what's going on, that's not going to be a public record. That analysis can shift if you take personal notes and then are sharing them with everyone else on the board, or the personal notes become more akin to the minutes. But otherwise, personal notes are an exception. What happens when you get a public records request? They can be made in person, by phone, by email. The law does not require someone who's making a public records request to identify themselves and to give a reason why. They have to be records that actually exist. The law doesn't require you to generate records that you don't keep or create a new record just to fill a request. And if you get a request that's overly broad, the law does allow you to reject that request and that they come back with a more definite request. I know, and again, the City of Dayton is going to be, as a local government, we're going to differ dramatically, and I understand that from preschool promise. But in our case, when we get a public records request, we have an individual who handles those and an office that handles those. And sometimes it requires legal review before the request is responded to. So that's something to keep in mind that Mr. Kidwell, as your attorney, would be able to address. This is just something to really be thinking about as we get started in regards to organization of the records. And because they have to be accessible, but the way and the method and manner that you organize your records is completely up to preschool promise. Case law has been very clear that you don't have to organize your records in a way that makes it easy to be accessible. You just have to be able to respond to the request once it's received. Understand that the law, of course, says it must be delivered at a reasonable time, and there's no bright line test for what that means. And it just depends on many variables, like the size or the volume of documents that's been requested. And so just keep those things in mind. One, and it wouldn't be advice, but a suggestion, and Mr. Kibble and I have discussed this, keeping records online makes them accessible, and it creates an easy way to manage and upload, and then it gives you an ability to direct anybody who's requesting to the record. So that's just something to be thinking about. And I don't know if you wanted to add anything.
No, and we can delineate the type of records that you might do that with versus ones you wouldn't. And then you and I need, I don't know if you have any thoughts, but record retention policies.
Right, I mean, you need to set a records retention policy and then make sure that it's being complied with in regards to the length of time. And I think the law is pretty clear about the requirements depending on the type of document.
Correct.